My name is Michael Young, and I'm a lawyer who handles life insurance beneficiary disputes across the country. In this video, I want to talk real quickly about a waiver of service of process. What is it? Well, let's step back and explain the interpleader lawsuit process. A life insurance company will file an interpleader lawsuit if they have received competing or conflicting claims to the proceeds of the life insurance policy. The law allows them to go to court, and often it's in federal court. They will file what's called an interpleader lawsuit in federal court and tell the court that they have a dispute over who should receive the policy benefits and ask the court to resolve that dispute. Now, as part of the interpleader process, they are required by law to name as defendants the competing parties, the persons who are claiming to receive the benefits as defendants in the case. It's not because the insurance company is suing them wanting them to pay money. It's because the law requires the insurance company to bring the competing parties before the court. So they will file a lawsuit. Now, part of filing a lawsuit is that you have to what's called serve a copy of the lawsuit with a process server to the person who's been sued. And that's typically happens in person. And when someone receives a copy of a federal lawsuit from a process server, they have 20 days to file an answer, or they could be defaulted. The court could find that they lose as a matter of law because they have not come to court. Now, Federal Rule of Procedure 4 provides an alternative method, and it's a method for someone who's a plaintiff in a lawsuit to not have to hire a process server. Instead, they just send in the mail what's called a waiver, and the defendant can sign that waiver and send it back to the plaintiff, in this case the insurance company, and tell the insurance company, look, I've received the lawsuit. You do not need to hire a process server to come give me a copy of the lawsuit in person. Now, why would a defendant do that? Well, first of all, in an interpleader lawsuit, you really do want to come to the court as soon as possible. There's no reason to wait till the last minute. But also, instead of having 20 days, you would have 60 days if you sign the waiver to file an answer. Now, once again, you're typically not going to want to wait that long, but oftentimes people have not hired an attorney by the time the interpleader lawsuit has been filed and they've been served. And so in that situation is extremely important. Once the insurance company contacts you and tells you that they're filing an interpleader lawsuit and they want to ask you to sign a waiver, it is extremely important at that point to call a lawyer who is experienced in handling life insurance beneficiary disputes.